So we're going to get started on this panel 2. If your heads aren't already filled, you better get ready because they're going to be even more filled after this one. Where the rubber hits the road is on this question of what we've titled security, surveillance, and encryption. You can have the laws you want, you can have the advocacy stances that you want, but there are pragmatic concerns and pragmatic issues that play themselves out, not just in devising policy, but in implementing policy. And so we've brought together a range of experts here that range from technology experts to legal experts to privacy experts to law enforcement experts to sort of begin to see what their conversation is all about or what their conversation could be about. So I'm going to introduce them as they talk rather than with any long introductions. You have perfectly good introductions in your book. And we're going to start with Susan Landau, who's professor of cybersecurity policy at Worcester Polytechnic Institute, and has been thinking about these issues for a long time in a little broader way than others, in terms of what some of the issues that we don't necessarily think about when we're talking about security, privacy, liberty, constitutionality, etc. So, Susan, would you like to begin?
Thank you. So I'm, as far as I can tell, the only engineer speaking today. I wanted to wear my pocket protector, but women's jackets just don't come the right way. So in the encryption debate, what we really need to understand is what the threats are and what the solutions might be. And you heard Dick Clark today talk about threats increasing, that he didn't mention, but it is absolutely true that we're a particularly wired nation, and that it's only going to, he did say it's only going to increase. And he did ask why no security and pointed out that security costs. I was at Sun back in the, when Sun existed, Sun Microsystems, in the 2000s, and I remember a discussion about cloud and asking, why aren't we putting this particular security protection in? We knew how to do it, we had all the technology, and the answer was customers weren't asking for it, and putting it in was going to cost us money, which we would have to pass on. Customers weren't asking for it. Security costs. Jane Lute asked, how do we assure integrity and assure integrity, and that our identifiers sorry, let me try that again. How do we assure that we have integrity and our identities on an open internet? The answer to all of that is crypto. Now, we had crypto wars back in the 1990s. The US government had controls on crypto. Academics and industry were pushing against controls on crypto. That changed in 2000. The US government loosened export controls on cryptography. They didn't completely remove them. There were still controls on computer and communication devices sold to governments, to communications providers, and custom-made systems. Everything else could go without a license. That was actually a very nice split. It left the NSA able to look at the stuff and rule on the stuff that was of particular interest to them, whether or not that could go abroad. The rest of it could easily go abroad, so it enabled industry in large part while still allowing NSA to do the job that it was supposed to do. While NSA was fully behind that change in 2000, and with an understanding, even though maybe it didn't posit Al-Qaeda, it certainly understood what the threats were. While the NSA was fully behind that change in 2000, the FBI was not, and the FBI has not been since that time. What were the costs of not allowing encryption to go abroad back in the 1990s? They were very expensive. The controls were on exports, but because of the way the industry works, it also meant that the domestic equipment, communications and computer equipment, didn't have strong crypto. It means that even today we're paying those costs. Communications and computer equipment have to be backwards compatible. When you pick up your smartphone and you call your grandmother's, you're calling and she's picking it up, or your grandfather is picking it up on one of those black telephones. I have one in my study just to remind me what they look like. It still works. But the point is, communications devices have to be backwards compatible. That's also true for things like SSL connections over the internet. They have to be backwards compatible with standards we had in the 1990s, which were 40-bit crypto. Some of you may have seen the freak attack that came out a few weeks ago. The freak attack is based on the idea that communication standards are backwards compatible. We're only as strong as the weakest crypto we have in the system. So when you hear someone like William Lynn, who was Undersecretary of Defense, write an article where he says the greatest long-term cyber threat we have is the theft of IP, and you know the protection is crypto, and you look at a US government policy that in the 1990s talked about restrictions of crypto and now is talking again about restricting encryption, you wonder what everybody's thinking. So I want to take the flip side now and say, well, how do you do investigations? I suspect I am the only one in this room with an accountless Android phone, and I suspect I am one of very few people in the room who have location turned off. That doesn't mean that I still can't be found, of course, because my phone is signaling to the system every few minutes. The point is that all of us now carry radio transmitters with us all the time. Every time we send a piece of mail, a text, every time we do a call, we're locating ourselves with lots and lots of metadata. Is that metadata useful? There was a student at Stanford who did a study called Metaphone. He found, looking at the data of where and when people called, he could determine somebody was investigating having an abortion, somebody else was having cardiology problems, a third person was planning to purchase a gun. Metadata is incredibly useful, which is why when the news of the Snowden disclosures happened, the very first leak was the Verizon court order about collection of metadata, why that created such consternation. Value of metadata is also really important in national security investigations. It was used to locate Khalid Sheikh Mohammed. It was used to locate one of the London July 7th bombers when he went down to Rome. It's used for triage. When the Boston bombers hit the marathon, one of the things that law enforcement was able to do was to figure out if they were part of a larger conspiracy or not. The point about metadata is, regardless of whether there's encryption, metadata is always available. You can't make a communication without having the information about when and between to which communication endpoints the communication happened. And in fact, metadata, even without names, is incredibly useful. If you know the location of somebody, 4 data points, morning and night, 4 data points, you have a 95% chance of identifying them, because work and home is a pretty good identifier of a person, regardless of whether they're living in a small town or a large city. So then we come to the encryption issue. And of course, on the one side, you have industry and academia arguing that we should continue to have encryption widely available, that strong encryption is needed in a globalized economy with nation-state threats, and so on. And on the other side, you have law enforcement, with national security making some sort of argument. It's not quite clear, although GCHQ has been very clear they want restrictions on encryption. I would posit that it's absolutely not necessary, and it's actually dangerous. It's dangerous for the reasons I've already mentioned. As for why it's not necessary, each one of you has a compromisable phone and a compromisable laptop. Some of you have compromised phones and compromised laptops. In fact, probably many of you. The point is, we don't know how to build secure software. We don't know how to build secure large systems. And that's what your phones are, that's what your laptops are. It is already the case that, it is certainly the case that national security has been using the compromises of devices to eavesdrop. That's part of the disclosures from the Snowden leaks. But it's also the case that law enforcement has been doing so, and has been doing so for a number of years already. How is it done? First, they need to get a warrant to go and look at the device to discover what applications and systems are on the device, what versions of these systems. Then they need another warrant to actually load the wiretap on. If the application is patched after the wiretap is on, that's okay, because the wiretap is already there. Now, when I say it's already been used, it's used routinely in national security investigations, and it is used sometimes in law enforcement investigations. It's going to have to be used more and more, because people will get more and more sophisticated about their communications. And it has to be used against the most difficult targets, because those are the ones who practice the best communications security. So I argue that the issue is not, should we make law enforcement and national security make it impossible for law enforcement and national security to do their investigations, or should we protect everybody's communications? But it's really a balancing act. And in a world where we have the kinds of threats that were described this morning, to me there's no question but that law enforcement and national security have to work a little bit harder. And that's where I will quote one of my friends retired from the NSA. He said, "The law gives us the right to get that data. The law doesn't say it has to be easy." Thank you.
Speaking of the law, we have here the General Counsel of the FBI. And I just want to say a few words beyond your title, just so people know why you know about this field, because you haven't been General Counsel.
In theory, I haven't spoken yet, so don't.
In theory, before you became General Counsel of the FBI, one of the things you did in your prior younger life was to be the master of all things FISA in the years before 9/11 and for a couple of years after 9/11, or a few years after 9/11. And that puts you, I just want to, preface your remarks with this, in a unique position to understand better than most of us in this room what actually changed and what actually stayed the same. And so you may or may not get to that in this part of it, because I think what you're going to address is sort of, does this matter? And if it matters, why does it matter? But I think I want everyone to know you have a little broader perspective, and I think it'll likely be reflected in what you say.
Well, Kiran, thank you very much, and thank you for this opportunity, and thanks to all of you for listening, and to Fordham Law School for making this opportunity available to all of us. Obviously, this is a very important thing that the public discuss, that we discuss in public, and that we hear from a variety of different views, a variety of different voices on these very important topics, I think, to the country, especially right now and going forward in the future. So thanks for pulling this together. So just for a few minutes, if I could, I'd like to talk about what we at the FBI and elsewhere refer to as the going dark problem. So I'll just make a few comments about that. The key point there, I think, is that this is really fundamentally about capabilities, not authorities, and that we do not have a perfect solution to this right now, but that I suggest we need to work together as a society to find one. So let me just walk through it really quickly if I could. So going dark. The basic concept here is that notwithstanding everything you may have heard in the past few years about the government's surveillance capabilities, significant collection gaps exist at every level. So what I mean by that is federal, state, and local law enforcement authorities have surveillance gaps. In other words, things, information, evidence, intelligence that they cannot collect today. It also applies to the national security realm, both inside the United States and, very importantly, with respect to our allies. It is a significant problem sort of across the board. It impacts our ability to collect evidence with respect to all threat actors. So that means terrorist groups, that means cyber criminals and cyber malicious actors. It means violent criminals, gangs, organized crime, child predators. It impacts the whole range of everything that we at the FBI and other law enforcement and national security agencies are charged with protecting society against. A key point, as I mentioned earlier, this is not, again, about the FBI or other governmental entities trying to get more authority to collect more data. What we're trying to do here is get the ability to actually collect the data that we're entitled to collect pursuant to the lawful authorities that we have adhered to. In other words, when we've gotten a court order in accordance with existing law, or when we've utilized other legal process to get authorization to go to a company to collect data, content, or metadata, whatever it may be, we are not able to collect that information, even though we've jumped through all the hoops, all the legal hoops that we're required to jump through. The two key aspects that I'll focus on, and this panel obviously is about encryption, so I'm just not going to say much about it right now, and I'm sure we'll discuss it at length. And encryption really there's two parts of it that we think about: encryption of data in motion, in other words, while it's being transmitted, and encryption of data at rest, for example, when it's on a device, a laptop, a cell phone, something like that. In addition, though, there's also an important part of the going dark problem that impacts us, which is I guess I would describe it as non-compliance with existing court orders, having nothing to do, or at least not necessarily having to do with encryption. In other words, this is when we show up at a company, we show up at a provider with an order or with other lawful process, and for whatever reason the company cannot comply with the order. It cannot provision the order. With respect to some companies, this is a problem on some of their platforms. With respect to other companies, it's all of them. So these are real significant issues that exist, and the result is that when we show up with the order, we don't get what we think we're entitled to get under the law. Very quickly, we understand that there are a range of very important values at issue here. Obviously, I've mentioned national security and law enforcement, but there are also issues with respect to, we understand, obviously, privacy, the competitiveness of U.S. companies in the global marketplace, innovation in this sphere, in the technology sphere, and the need to have the ability for free expression of ideas around the globe, in the United States and elsewhere. They are all very important values that we need to try to figure out how to balance appropriately. We understand that U.S. companies operate in a global marketplace. It is a very competitive world. Their customers, users, competitors, and regulators are around the world. And as they think about these issues and as they think about these problems, we know that they've got to confront and deal with that very tricky environment. The FBI, obviously, well, not obviously, I don't think everybody believes this, but I will say to you that we are in the business of protecting privacy. We spend a huge amount of effort right now, especially in dealing with malicious cyber activities. A lot of that is about protecting privacy because that's, to a significant degree, that's what cyber criminals and other malicious actors are after. So we're totally in support of that. And we're in support of well-managed, well-executed, well-designed encryption because it does protect the security of the country and when used appropriately is a common good. As I've said, we do not have and we are not promoting a single or multiple set of solutions to appropriately balance all these different competing interests. But my suggestion is that we have to do something. We must move forward in a positive way with respect to trying to figure out how to address these issues. And in relation to that, I'll move toward the end here. It's critical when you're thinking about these issues, especially now I'm focusing on encryption, to think about what the world will look like and is already looking like in a world where there is robust and widely distributed encryption. And so this means, I just want to make sure that we all understand, this means that the government will not, in certain circumstances, be able to collect evidence or collect intelligence with respect to, for example, the communications of our enemies during wartime, using U.S.-designed and U.S.-operated communication systems, right? That is what we were talking about here. And the enemies include terrorist groups in the current environment. Same thing, I mentioned child exploitation cases, child predator cases. We will not be able to collect that evidence if we move to a world where more and more information is encrypted and nobody has the key. The key thing, it seems to me, and since we're in a law school, so I'll talk about the law for a second, the key thing, with respect to the legal standards and I think the rule of law, to take it up to a little bit of a different level, the question really is, under what circumstances as a society do we think that the government should be able to obtain information in these kinds of cases that I've talked about, right? And remember that the Fourth Amendment, for example, protects us against unreasonable searches and seizures. It does not protect us against all searches and seizures. And historically in this country, when the government has jumped through the hoops in accordance with the Fourth Amendment and obtained what has been traditionally thought of as the gold standard with respect to privacy, a Fourth Amendment warrant that you have to go to a neutral and detached magistrate to get based on probable cause, we've historically thought that's enough to enable the government to conduct a reasonable search anywhere. And so if we don't do anything, if we just fail to act, we're moving into a world where those legal authorities will be in effect a nullity, because when the government shows up, there'll be nothing that we can get. Karen, thank you.
I just want to follow up on one earlier thing you said. You said that the companies can't comply. Why can't, if they don't have? Why? Or it's not that they won't comply; it's that they can't comply. Just
they struggle technically with being able to do it in a timely fashion.
Okay. All right.
Because of for a variety of reasons, but including the complexity of their own networks.
Well, so I'm not sure this is true, but I'm going to go back through the transcript to see. because I'm a little embarrassed, but is it possible you're the first person to mention the Fourth Amendment today? It's like 2:30.
I'm not sure, but
Okay, well, well, you're going to let's use the next hour to talk about the Fourth Amendment. And so let me turn now to Tien, who is a staff attorney at the Electronic Frontier Foundation, which is, if you don't know what it is, it's a site that you should get familiar with, because in addition to the ACLU, they often cover these cases, these issues, and are really out front on it. And so, Lee, why don't you weigh on this issue for us?
Sure. So a lot of the discussion about surveillance reform and computer and network security has, at least from our side of the aisle, and I'll include ACLU here, has focused on the civil liberties threat from government data collection or from government acquisition of data from the companies. But what I want to focus on today, in the context of this panel, is something that I think is even more corrosive to our system of law and more of a threat to democracy. Well, it's good to get attention.
My deepest apologies. If I don't have a heart attack, then their life safety system isn't so great. I just want to say. All right, go ahead.
Right. So I think where I was about to talk about secrecy, and my basic premise for this panel today is that, and really for the day, is that for all the things that we've talked about what we might do, about trust deficits, about problems that we have in doing any kind of partnership, the impacts of the Snowden leaks, that the most important thing is something that we've barely talked about, which is the need to actually reform the classification system in the federal government, because it's well known, and every report on it for probably 20-something years has said we classify too much information. Much of what we classify, or what remains classified, does not need to be. It costs the federal government an enormous amount just in dollars. It messes with all of our accountability requirements. It's a huge drain on anything we're trying to do in this area. And yet you barely have any kind of attempt, say legislatively or in all of the discussion since the Snowden leaks, about what we will actually do about it. I mean, the Leahy USA Freedom Bill from last year contains a bunch of surveillance and transparency reporting types of requirements. Those are good. Most of those are already in large part sort of in operation, at least with the companies. But really, aside from that, the only structural reform that it promised on this sort of declassification and secrecy area was with respect to the FISA court, the special advocate or amicus provision, and provisions for declassification of significant or novel decisions around the law. So I see, the Snowden leaks. I see any time something comes out as a one-time snapshot about some secret programs, but it always makes me wonder, and I think it makes a lot of people wonder, what are we not being told about? And so I think that if we don't directly address this problem structurally, we'll delude ourselves into thinking that legal reforms, procedural reforms, will successfully govern surveillance. But I think history teaches us that it is in the nature of what the intelligence community does that they try to find. They have a strong incentive structurally to conceal their activities from democratic accountability. That's, it's what they do. But we know that, and we should be trying to do something to actually counter it. And right now, I don't think we do. Now, on the judicial or litigation side, you not only have the secret FISA court, but even in ordinary courts, EFF, my organization, ACLU, we've spent an enormous amount of time trying to litigate national security surveillance and we have foundered on issues that don't go to the merits, like standing. And the reason why we founder on issues that don't go to the merits is because classification and the state secrets privilege are a huge barrier to our ability to even have any kind of review of the record, or even to bring the record into court in a meaningful way. But to the extent that our system also relies, or is supposed to rely on, congressional oversight, the problems, I think, are even worse. I would characterize our current congressional oversight model as an elite oversight model. It relies on the select intelligence committees of the two houses, the various gangs of 4, 6, 8, whatever, to sort of manage this sensitive information, but it excludes the other members of Congress. It excludes many staff members. And it's seemingly, I would argue, that many of these committees have essentially been captured by the intelligence community. And this makes it difficult for the members themselves. And I always will think of Senator Wyden, who was a member of the Senate Select Committee on Intelligence, who was vaguely warning for quite some time about interpretations of the Patriot Act being used for surveillance that he claimed would shock most Americans. But he wasn't able to say anything more, and we all puzzled, or those of us who wonk out on this stuff, all puzzled on what he was talking about. It wasn't until really much, much later, and because of Snowden, that we were able to find out. And that's because the information was classified. And it enabled the executive officials to mislead the public, secure in the knowledge that a member of Congress who actually had been briefed on it couldn't gainsay them publicly without breaking the law. So, obviously there are a lot of issues here, more difficult ones around operational facts, I think, although I'm not going to concede that all sources and methods automatically should be protected. But what I want to focus on here is surveillance law. What does the law mean? We talked earlier about, many people have talked earlier about how we should have a discussion of what the NSA does or doesn't do, what the intelligence community does or doesn't. But an important component of that is how they are doing it in relationship to the laws on the books. And we need to be able to understand what the laws mean, or how the executive branch is interpreting the laws, and how the courts that are actually Article III courts, supposedly on the issue of FISA, are actually interpreting the law. And if we don't know that, we do not know enough about what our government is doing, and we don't know enough about how to...
It's failing. The test is failing. Sorry.
May I have your attention, please? This is your fire safety director. We are currently undergoing a test of our life safety system. Please disregard any alarm tones or strobes you might see or hear throughout the building.
Go ahead.
Okay, I'm going to resume.
The laws.
And I don't want to limit this discussion to national security secrecy either, because we see structurally similar problems with law enforcement surveillance. You can easily segue from criticism of NSA tailored access operations and attempts to exploit vulnerabilities to criticism of the FBI's position on encryption. We can also point to the DEA call records program, which apparently inspired the NSA's program, the secrecy surrounding Hemisphere, the non-disclosure agreements that law enforcement agencies follow. So anyway, I'm going to close really quickly here. I think the problem is deeper than just the policy, right? We have this classification problem. We have the structural problem with the intelligence community and incentives to secrecy. In the law enforcement side, we have a structural system of ex parte hearings before magistrate judges or judges in order to obtain interception orders or records order. Again, these occur in a non-adversary setting. There's no way for anyone who represents the public or a defendant or the Constitution to actually be in there. So that is, problematic. My very last point, and I'm going to see if I can do this before I'm interrupted, is technological transparency, right? We've seen in ordinary law enforcement practice that judges often aren't sure what the technology they're asked to authorize actually does, how it does it, and even what implications it might have for society were the use of this investigative technique broader. So these ex parte procedures really developed in a time when we didn't have major questions about how the things were going to be working, and now we do. And similarly, we see the Fisk opinions where it's really clear Fisk judge didn't really understand how an acquisition technology worked or how an internal processing technology worked, and we know that they were pretty much at the mercy of whatever the government told them about it. That's not really the right way, I think, to run a system where you're actually trying to check, trying to balance out, trying to counteract the incentives that the government agencies have, which takes me back to the NSA and encryption. Susan was saying that, one answer to law enforcement dealing with encryption is the insecurity of our endpoint devices, but it also seems like, therefore, if we're going to weigh that case, if we're going to talk about that as being a balance for strong encryption, we need to know as much as possible about the actuality of the government's ability to subvert endpoints, because the more powerful they are at subverting endpoints, then wherever it falls, if we can't quantify it, if we can't actually understand it, we're not actually going to be able to guide our policy decisions. That's it. Thanks.
Thanks. Kiran Raj is in the Deputy Attorney General's office at the Department of Justice. And thank you so much for coming. And Lee mentioned at the very end here law enforcement and sort of the criminal justice system. And just he made a distinction between intelligence and law enforcement. And maybe you could talk a little bit about how you see the different questions that are confronted by your position as opposed to all these other comments.
Sure, and thank you, Karen, and Fordham Law School for having us here to have this important discussion. One of the things I've noticed in a lot of these debates when it comes to national security and law enforcement is that we tend to conflate a number of different complex and important issues. So maybe up front I can start with potentially walking through some basic premises and try to bring some structure to some of the debate. So first, I think a sort of basic and obvious premise is that important evidence is increasingly in electronic form, which means that access and obtaining electronic evidence is essential to preventing and solving crimes. Nearly every criminal investigation that we undertake at the Department of Justice, whether it's a white-collar fraud case, a public corruption case, a child exploitation case, or a case involving violent street gangs, all of those investigations, or nearly all of those investigations, involve electronic evidence. So, and Jim talked about this a little bit earlier, but when we talk about the different evidence, usually we categorize them into two different buckets. One is data at rest, so that's data stored on devices, and the other is data in motion, which is data that transits over telecommunication networks, for example. So how do we access this information? Well, at a principle level, we have had for several hundred years a constitutional balance, where on the one hand we have the right to privacy, and on the other hand we have the need for society to access evidence to solve crimes and stop and enforce the laws and protect public safety. Now, as a general matter, what that has meant is that where a person has a reasonable expectation of privacy, law enforcement is required to get a search warrant by demonstrating probable cause to a neutral magistrate. That's a principle. So those are the principles that we've had to balance over several hundred years. And over time, that balance changes depending on technology and how society has evolved. And where encryption, I think, fits into this debate is that encryption is a valuable tool. There is no doubt that strong encryption promotes privacy and information security. Law-abiding people rely on encryption. Government relies on encryption. And smart use of encryption can decrease our vulnerability to data breaches and other serious cyber crimes that we see criminal actors committing. But on the other hand, we have the other piece of the tool, which is that the widespread availability of encryption in, for example, mainstream consumer devices poses a significant challenge to that balance that I talked about, because it risks making that balance irrelevant. So what do I mean by that? One example is that no matter what the police can show, regardless of what probable cause showing they could make, regardless of how serious the crime is, regardless of how timely and necessary the information is, law enforcement may not be able to get access to that information. And so what this means in practice is we have potentially situations where criminals can freely communicate or store incriminating information or contraband beyond the reach of law enforcement. There are these safe zones for criminal activity. And so I guess I would say we need to work together to address this challenge. As Jim mentioned, we as the government don't have the solution to that problem. We need to find a solution that promotes both strong encryption to protect privacy, but also allows lawful access in order to ensure that we can protect the public safety. And that, I think, is the big challenge. And it's a big challenge for us, not for the government, not for any individual, but for us as society as large.
So Ben, help me out here. No,
I'm going to help you out very briefly, since this panel is about 12 feet long.
Right. But we have lots of time.
Yeah,
But first,
okay.
I want to say one thing to you. Everybody, from every point of view here, seems to feel like they don't have information they need. You know, like if it's people wanting to know what the NSA does, they don't have the information they need. If it's people wanting to know what policies are actually being used, they don't have the information they need. If it's the FBI and they're trying to find evidence, they don't have the information they need. So this seems to me a piece of this is that everybody feels on every side here that they are entitled to information that they don't have, that it's hidden. And this seems to me a place where what you do fits right into the conversation. So I'm just wondering your thoughts on these larger issues. And take as much time as you want. We have all afternoon.
I'm actually much more interested in having exchanges and asking questions of fellow panelists. But if Jim was the first person to invoke the Fourth Amendment today, I think Susan might have been the first person in a conference on cybersecurity to acknowledge that there is a conflict and a tension between cybersecurity, defending our networks, defending secure and private communication, and surveillance that relies on creating and exploiting vulnerabilities in those systems. And I'm disappointed that Susan was the first person to raise that conflict and that we didn't hear about it from Richard Clark and that we didn't hear about it from Mike Morrell, both of whom sat on the NSA review board that actually had a very valuable conversation about that tension and the role that the NSA played. And how the NSA is using so-called zero-day vulnerabilities instead of reporting them and disclosing them to technology companies to patch those fixes, undermine security and undermine trust, and how the NSA prioritized its offensive mass surveillance capabilities over its other mission, which is securing networks, where NSA is sort of uniquely situated to play a much more constructive role. So it's too bad that we had to get this far and we didn't get the perspectives of those officials.
We need a two-day conference.
Yeah, or
Or something else.
So Mike Morrell said that if you want to really understand the NSA, you should go back and look at the 60 Minutes love letter to the NSA that was pretty widely reviled in the media and among neutral observers. I would say that if you want to understand the NSA, you should go back and read Shane Harris's profile of General Alexander in Foreign Policy magazine, 6,000 words, and really, really eye-opening. In that profile, we learned really I did, that General Alexander, and I mean this non-pejoratively, was one of the most talented bureaucrats in the history of the intelligence community, that he was very technically adept, that he was intoxicated by the capabilities that the NSA was developing, and that his mantra was that we should essentially collect it all with the confidence that the authorities and the budgets would follow. And part of his talent lay in the kind of shows that he was able to put on for his overseers. He created, according to Shane, something called the Information Dominance Center, which was designed by Hollywood set designers, actually had the doors like on Star Trek that open with a whoosh. And there he would bring members of Congress to come and see the toys that they were paying for and all the neat things that the NSA could do. And it seemed to me that there was a period of time in which the NSA was allowing its capabilities to dictate its practices, rather than having a public debate about how those capabilities ought to be constrained by our laws and values. And actually, you've heard many people in the NSA essentially make versions of this point since the Snowden revelations, that had they been more transparent about what it was that they wanted to do before, they might have been in a better position in these debates, rather than not only withholding this information from the public, but as Lee said, affirmatively misleading the American public under oath about what they were doing. And part of the story that the Snowden revelations tell us, although it's one that people who have been watching this issue have known for years, is that surveillance has gotten very cheap. One of the real constraints on government surveillance historically, in addition to law, has been cost. And it simply used to be the case that if governments wanted to track us, if they wanted to know where we were and what we were doing, they had to invest real resources in doing that. And so they had to make resource-based decisions about which of us they were going to follow. That's really not necessary anymore. It's now, if in the past you might have needed teams of FBI agents to track somebody's location, now one agent at a laptop can follow thousands or tens of thousands of people in real time or get their historical records, because we are all carrying these trackers in our pockets, as Susan said. And this sort of brings us to the issue of encryption. And one way of thinking about encryption, and I don't suggest it's the main way of thinking about it, but one way of thinking about encryption in this context is that it makes surveillance more expensive again. It restores the sort of prior status quo in which governments really did have to make decisions about who it was that they were going to track, rather than being able to passively collect, billions of communications in unencrypted form and store them. Storage is another thing that's gotten incredibly cheap. It used to be expensive to store data, and now it's basically free to do it. Governments are now going to have to make decisions. Now, you heard the term from Jim, going dark, that encryption and related technologies are creating areas where law enforcement, even with valid legal authority, won't be able to go. I think that's probably true. The extent of the problem is very debatable. We hear from others that we're in a golden age of surveillance for government, simply because the digital trails we leave, even with encryption, provide so much rich information about us, our associations, our contacts, our activities, our locations, that can't be concealed using encryption, that law enforcement has more information about us than ever before, even if we all encrypt the content of our communications. And we also heard from Susan that at least the more sophisticated law enforcement and intelligence agencies can defeat encryption, not by going through it, but by going around it, by, for lack of a better term, hacking us. We know that the NSA does this. The NSA should be able to do this. We want our agencies that we spend tens of billions of dollars a year on to be able to target individuals and to be able to break through whatever defenses they have. We know the FBI is doing this, that they have units that get warrants to hack devices, to install malware, to track people. We should know more about it, as Lee says. We want to make sure that they're doing it in a tailored and targeted way, that they're not causing broader harms to networks, that the way that they're getting information and retaining it is minimized and not limitless. So I don't mean to suggest that the conflict isn't real. I do think that we are going to reach a point, and we may get there sooner or we may get there later, where there is information that many of us would think that the government, that law enforcement ought to be able to get. They've crossed their T's, they've dotted their I's. They've gone to a judge, they've gotten a warrant. They have probable cause, they show up at a technology company, and that technology company cannot comply with that warrant because they have created a system that is secure and is not available. But I want to actually say a word about why that's the case, which we didn't hear from either of our government colleagues here. And that is that these technology companies cannot create design systems that will allow compliance with a US government warrant and that will also be secure from the intrusions of bad actors and the demands of foreign governments. These companies are multinational. They're not just operating in the United States. If they can turn over information with a warrant to the US government, they can turn it over to the Chinese government, and they can turn it over to any other government. If they don't design their systems, if they build a back door or front door in that allows compliance with that piece of paper from a US judge, then they are much more vulnerable to foreign actors, to criminal hackers, and to other kinds of intrusions. And so this is actually a real conflict, and one that we need to debate not just on a legal level, but also on a normative level. Which of these things is more important? Richard Clark testified in Congress about the NSA review panel, and he said, look, it's more important that we be able to protect our stuff from China than that we be able to steal theirs, because ours is worth more. Mm-hmm. Acknowledging this conflict, that there are competing design requirements here, and saying, I come down on the side of defense if I'm pushed into this corner and have to decide between these two things. And let me just close by saying, it was quite extraordinary to see the FBI director go to the National Press Club and attack Apple, the world's most profitable corporation, for designing an operating system that's too secure, that makes even lawful surveillance difficult or impossible in some circumstances. But I want to suggest that kind of friction between these hugely powerful entities, these enormous technology companies to whom we entrust our data, and law enforcement and intelligence agencies to whom we entrust our safety, that this conflict might actually be a good thing for liberty and for our democracy. It might be a different kind of check and balance. And I don't just mean that in one way. I don't just mean that I want to see technology companies, protect my rights and my privacy from government. I also would like to see a more active government in protecting me as a consumer from these technology companies. It wouldn't be the FBI doing it; it would be the FTC and others. But that you could think about the other use of the word check and balance. The check that you write and your bank balance, and see this kind of conflict as one that actually may, in the same way that the media plays the role of a pillar here, be important for liberty.
Jim, can I follow up on just a kind of theoretical thing that Ben started with, which is that law enforcement, intelligence has way more access to information than they've ever had before, even without, before you get to the encryption issue. Even with encryption, there's just vast amounts of more information, and how that just plays into the calculus of how you think about this in terms of the problems of targeting and the need to target to be in compliance with the Fourth Amendment and other laws.
That's a pretty big question. I'm not sure I can slice it up in a sensible way right now, but I think the struggle for us is, believe it or not, we're not interested in most or nearly all of that data. We don't have any interest in it, and the challenge is pushing away all that irrelevant stuff to get to the very, very narrow slice of that which we are interested in, and so that's the challenge for us. And so, yes, sometimes you need to obtain a certain amount of data in order to make sure you've got the bad guy within what it is you're looking for, but then to quickly get rid of it in a decent way that protects the privacy of Americans, what I'm trying to say, and that focuses you on the target, because that is what we're after. I think I would acknowledge that I don't think we've always done a good job of explaining that that's really what we're after. These data collection programs and so on and so forth. It's really about winnowing it down as quickly as possible to deal with the adversary that is moving very, very quickly, very often.
And do you think that there has to be some reform in minimization procedures or minimization law, or do you think what's standing on the books now is capable of doing what you just said, which is quickly getting rid of what they're not supposed to have, that's not a target and that needs to be cleared out from minimization?
Yeah, I mean, I guess I would say the law itself, the statutory framework with respect to this is adequate.
Right.
Because what it talks about is having minimization procedures that are reasonably designed basically to, on the one hand, protect privacy, and on the other hand, enable the government to obtain, collect, and produce foreign intelligence, at least in the FISA context. So the structure's there. It's that you've delegated it. I mean, the American people, through their elected representatives in Congress, have delegated that to the Attorney General and the FISA court, for example, to strike that balance with oversight from Congress, with oversight from inspectors general, et cetera. So I think the law is okay. It's just keeping up with technology, making sure that what we're doing makes sense, understanding the technology, having the technology translated to lawyers and then to judges and so on. I think that's the trick. But I would say that the law that's not an area where legal reform is like crying out to be had.
Susan, you look.
So I want to cast your remarks earlier in a slightly different way, and I want to say that what we're partially talking about here is security or surveillance. And it's not surveillance inevitably implies better security, but that in fact surveillance sometimes is an opposition. And I want to give the audience 3 examples. 2 are very well known, the third is not, but you're a law audience rather than a tech audience, so you may not know any of the 3. Greece. So after we passed the Communications Assistance for Law Enforcement Act back in the 1990s, which said all digitally switched telephone networks had to be built wiretap enabled, the FBI also talked with police in foreign jurisdictions and urged them to get similar laws passed. And there were Greek standards for this. Ericsson developed a phone switch, which it sold to Greek Vodafone. Greek Vodafone did not want the wiretapping capabilities, didn't pay for it. It wasn't switched on. In fact, it wasn't even in the original switch. It appeared in an updated version of the switch, but because Greek Vodafone hadn't paid for the wiretapping capabilities, it wasn't turned on, and also the auditing capabilities were not part of the switch. Normally, when you wiretap, you have auditing capabilities on there that go on. So what happened next is between June 2004 and I think about March 2005, maybe a bit earlier. It was a 10-month period in which wiretapping was turned on 100 senior members of the Greek government, including the Prime Minister, the head of the Ministry of Interior, the head of the Defense, the head of the opposition. The wiretaps were sent to 16 cell phones. That is, the wiretapped communications were sent to 16 cell phones in the Athens area. At one point, an SMS went awry, and at that point, the wiretapping was shut off. I've now told, and how did the whole thing work? The thing worked because at some point, a rootkit was put into the switch. That turned the wiretapping on because auditing was not part of the capabilities of the switch. There was no auditing. And because it was a rootkit, every time the switch got updated, an automatic update of one sort or another, what happened next is that the wiretapping was updated too to accommodate. I've now told you technically how it worked. If you want to see more details, there's a wonderful article in IEEE Spectrum called The Athens Affair. I haven't told you who did it because we don't know officially, although there have been some guesses. That's the first one. Second one was between 1996 and 2006, 6,000 members of the judiciary, sports teams, referees, actresses, business people were wiretapped in Italy without legal authorization. There's a court case that is continuing to go through in Italy. When I've told you the flavor of people who were wiretapped, you now understand it was done for bribery and blackmail. When I tell you it's 6,000 people in a country of 60 million, I've told you that no business deals, major business deals, or political deals were secret during that time. The third one is something that was described in the Washington Post a few years ago. Google, like all major communications companies, had various wiretap orders served to it by the US government. In the database where the wiretap orders were, well, let me phrase that differently. The Chinese government, the Chinese hackers hacked into the database that contained the names of the people who were being wiretapped under orders of the US government. Now, if you're trying to do counterintelligence, what's the best way to discover whether or not your agents have been compromised and known? Done. What's the point of my 3 examples? When you build surveillance capabilities into communications networks, you unsecure communications networks. The only thing that can secure is end-to-end. I described earlier a way to defeat that. It's an expensive way, but we go back now to what Ben said about changing the costs and perhaps re-triggering them to a different place. And I certainly agree with Jim that there will be times when you really want to go after a bad guy, and we've made it very expensive. But on the other hand, given the kinds of cybersecurity threats that were described earlier today, that's probably the balance you want to seek.
Karen, you want to weigh in on that? Security versus surveillance, is that the...
Sure. Yeah, I think, one of the things that we tend to get caught up again here when we talk about the costs at the federal level is we forget about our state and local counterparts in law enforcement, and they frankly just are not resourced at the same level as the federal government is. So that's just one thing that I think when we think about the balancing of the costs, even if we sort of adopt some of Ben and Susan's approach, that we need to factor into our analysis. But the other thing I do want to pick up on is the back door, because it's an issue that tends to come up from time to time whenever we talk about encryption. And I'd say a couple of things about it. One is, I think it's a misnomer, because it suggests that the government is advocating for some type of access point which is wide open, that anybody can walk in, whether you're a cyber criminal or another government entity or our government. That's not what the government, as far as I know, that's not what the government is advocating for. And in fact, that's why we want to make this a public dialogue, because we know that we're not the ones that necessarily have the solutions. We think about this as smart access, right? It is a truism, I think, from a technological perspective, that anytime you add another access point, you are incrementally increasing the risk to the system. That's a truism, but I think the real question is, how much are you increasing the risk to the system? How much vulnerability are you introducing into the system? And frankly, the people who would know that the best are the technology companies that are developing the system. And Susan said at the beginning that she was the only engineer on the panel. And I started off as an engineer, but now I'm a lawyer, so I don't know what that makes me. Maybe half an engineer. A lawyer, yeah, exactly. So I think she was right.
I've been writing policy papers, so I've gone the other way too.
But one of the things that, from my technology career, I would say is, when you design a system, you have to design it from the ground up with security in mind. That's the best way of doing it. So when we try to patch on access points or other things like that, it does make it more difficult. And that's in part why we want to work with the tech companies at the ground level to ensure that when they create systems, they can make it so they're not vulnerable, even if they are introducing other access points. So there are a lot of different solutions, and I don't think there's a one-size-fits-all solution to this problem.
Can I jump into a response to Kiran, I absolutely agree with you with state and local. I testified a few years ago in Congress, and there was Val Caproni, one of your predecessors, and the head of the state and local chiefs of police, and he was talking about the wide variety of cell phones and that they couldn't possibly. That's of course true, and forget about encryption, just the complexity of the different number of communications devices already makes it impossible. That argues actually for some sort of resource at the federal level that the state and local tap into. So I think that's true regardless of where you tap into in the sense of use. I saw Lee jump a half mile. On the increasing risk part, the point is we live in a globalized economy, and anybody who works in a business, so-called American business, it's not American, it's multinational. If the US has a way to access the communications, the UK wants a way, France wants a way, Germany wants a way, South Korea wants a way. And the complexity of such a system, as you know, anytime you add an access capability, you get a more complex system. When you add multiple access capabilities, I don't know how to keep it secure. And that's with my engineer hat on.
And let me jump in here. First of all, one of the things to remember is that what Kiran was just talking about is really talking about the government coming to help the private sector design the technologies that we're all going to use. That's the implication of needing to build in that kind of access point and not bolt it on later means that any company, in theory, that is in the communication space and working on devices and communications should be looping them in on how they're going to do it to make sure that there's not going to be an incompatibility problem or protocol issues or whatever. So I think that's actually a remarkable sort of call for partnership, because I think that's actually sort of pretty bad for privacy and pretty bad for innovation. And it's one of the reasons why we've been concerned over the years with the FBI's attempts to sort of expand the scope of CLIA precisely because of greater involvement by the government in the design of our private sector systems. The other thing I want to come back to, though, on the encryption issue is just to remind everyone that we aren't just talking about the stuff that we know about in terms of CLIA and lawful access. And again, I don't know how much of this we can actually be sure of, but there's a cryptographer at Johns Hopkins, Matt Green, who sort of summarized what he took from the NSA Snowden leaks about the NSA's involvement in encryption. And it has been, and he lists the tampering with national standards like NIST to promote weak or otherwise vulnerable cryptography, influencing standards committees to weaken protocols, working with vendors to weaken encryption and random number generators, attacking encryption used by the next generations of phones, obtaining clear text access to major providers that were claiming to be using encryption, establishing and really somehow subverting the HTTPS and SSL certificate system. I mean, what we're talking about really, if those are all true, and I don't know for sure, but that's what the evidence indicates, is a very, very significant attack on the overall security of our communications. And it's going on in a way that isn't tailored to the target that you particularly want to get to. It's really affecting the privacy and security of everyone who uses the internet. And if we're really serious about not wanting the big data and really about trying to winnow and trying to get away from it, then the emphasis in the Fourth Amendment really isn't on so much on a warrant or probable cause. It's on the particularity aspects that are part of it. And that's where we're really falling down, because there's so much of a mantra, there's so much of a call for big data, but big data is the opposite of particularity. Big data is the opposite of any kind of notion of an actual targeted surveillance. And I think that's right now, that's one of our big problems.
Can I just clarify one thing, Karen? I just wanted to make sure my comments weren't taken out of context, which is that we're here to talk about the problem and that we want to have a dialogue about the solution. I wasn't advocating any particular solution. I think Lee suggested I was. So I just wanted to clarify that remark.
Yeah, I was just going to emphasize that also that we are all in favor of the competitiveness and innovation in the U.S. industry, and we are certainly not interested in dictating or telling or trying to figure out how to network a platform or anything like that, or design a platform. It's the jobs of the companies to handle their own networks. The issue is that we experience is when we show up with an order, we can't get what the order says we can get. It's over to them to try to figure out how to do it. So we're certainly not. We at the FBI certainly are not trying to tell anybody how to design their network.
Can I ask Jim and Kiran a question? Because one of the things that we're hearing on this panel, and I think we've heard this in other conversations where technologists and law enforcement have come together, is the law enforcement community saying, in good faith, we have a problem, but this isn't a moon landing. We can figure out a way that we can accommodate all of these interests. We can actually do targeted surveillance without tearing open the security of the networks. And then technologists saying, no, you can't. In short, basically saying you actually can't do that. And so without asking you to take a position for the government, but we are talking about possible solutions here. When you say, let's work together and figure this out, for example, what do you mean? in perhaps in layman's terms or even non-layman's terms? How can these things be accommodated? What would be a way of doing that?
Yeah, I guess I'll give an example. And again, these are examples, and as Jim mentioned, the private sector will, and these are examples from the private sector. So one example, we know, there's software out there like where an employee has a laptop that has encryption on it. The employee leaves. There has to be some way of getting access to that information, whether it's disaster recovery or otherwise. So private companies have those services where there's another way of accessing the data that is encrypted that's not from the employee putting in a password. That's an example. There are others throughout the private sector of multiple access points and yet still having strong security.
I have a question. When these policies are being debated, like what you just talked about, is it left to just the whoever happens to have these positions at the Department of Justice or the FBI, or are there people who are specialists in addition to technologists, people who are specialists in civil liberties issues, Fourth Amendment rights concerns? Are they brought into the conversation, or is it just assumed that this is something that because you're lawyers, because you understand this, you can also opine on? How does that work in terms of having the conversation?
Well, I mean, it's a multifaceted problem, which really requires, I think, a whole of government approach. I don't know if there's a better way of answering that.
So there's no okay, all right, just kind of wonder, because from the outside, we actually don't know how anything works. We're very curious to know how seriously, it's how these conversations matter. I have one final question, and then I think we should open it up to the floor. And my question is I want to ask you, Jim, just in terms of, because you've served in the government, then you weren't in the government, then you are in the government, that how much, and you might not want to answer, and you can just say, I don't want to answer that question, because it's a historical type of question. But when we talk about this issue of trust or not trust, or of a kind of distrust of using the targeting procedures and the minimization procedures, and then you hear from government officials saying, no, we're following these rules, and it's not what we want. We don't want mass collection of information that we keep and retain, right? Do you think it's in part the legacy of the policies that were, some of them exposed by Snowden, many of them exposed by IG reports much earlier, that there's going to be a while of sort of playing cleanup from what happened in the past? Or do you think this would be the conversation no matter what, given the new technological age that we're in?
Well, I think there was a trend toward increased encryption, and I think the revelations with respect, or attributed to Mr. Snowden, accelerated that trend rapidly, and also gave, I don't know what, enhanced the public debate about it, or increased the level of the public debate. So we were headed this way anyway to a significant degree, but that has accelerated it. I mean, and I understand and agree that the government has to, maintain. Governmental entities must maintain the confidence of the public. That's been talked about several times here during the course of the day. We know that. We accept that. We do think that we are accountable to democratic institutions. And I think in terms of your policy question, that plays out, right? Because there are a variety of voices when you factor in all the different players that are at issue within the executive branch, within the legislative branch, and then outside groups having influence in both of those arenas. I would tell you that all voices are heard at the table, one way or another. It waxes and wanes as you go through a particular discussion, depending upon who you have in a meeting. But by and large, overall, all of the voices are represented, I would say.
Okay, interesting. Time for your questions, if you have any. If not, we will. Joshua.
The question of capability versus authority, doesn't that beg the question with respect to collection as a whole in this context? Because doesn't it distort the meaning of privacy as a whole as well and turn privacy into something passive? And just two aspects of that. One is a person can choose to be private, and in the sense of someone, it's not just passive of what the government can collect or not collect, but also how I choose to act. So, for example, if I choose to have an in-person meeting to discuss something, the government can't make me have it in a telephone call, so it can monitor it. So if I choose to encrypt, That's a personal, proactive privacy choice. The second part is, in the context of capability versus authority, is that in the world we live in, not so much, but everyone has to, if you want to engage in commerce, in social action, anything, you have to be engaged in the larger network that creates all of this information that didn't exist before that way. So much of what you could do in a commercial or social sense without any trace now is all traceable. So in the context of privacy, hasn't that changed the concept really from one of authority versus capability to really one of whether someone can choose to be private and whether or not that is a reasonable expectation of privacy under the Fourth Amendment that has to be honored. I just must also say one thing which is not a question, I apologize, but all day from every government or quasi-government official, all we've heard about is the need for, or the desire for dialogue. And that rings hollow in this sense, is that for 15 years until Snowden, it was the government that resisted dialogue altogether. And now that the worm has turned, the government wants dialogue. But I submit to you, to government officials, this is not personal, this is really because we've heard it from every person today, is that dialogue in the context of the trust that has been forfeited is not sufficient. You have to do something about it.
Well, there's a lot of stuff there to chew on. So with respect to the trust issue, I mean, I hear you and I get it and I understand that people are concerned. At the same time, we followed the law. We followed the law as directed to, as enacted by your elected representatives, as enforced by the executive branch, and as overseen by both the judicial branch and the legislative branch. So in terms of that, I mean, it's not as though this is not some bygone era in the past where the government was running amok and using national security authorities to justify some other type of collection, some abuse. This is where the government was engaged in wartime with respect to the collection of communications targeted or intended to be targeted at the enemy, where we were trying to protect the country following law. So in terms of the trust, I get it, I understand it, I'm not trying to run away from that, but I just think we need to keep that aspect in mind. With respect to the issues of privacy, look, privacy is really hard to understand, I think, now in terms of the number of, the amount of data that we all know that we're spewing out at all times and the amount of data that we voluntarily share with the world. So I think that's pretty challenging. At the same time, though, I mean, for example, in your home, you are certainly entitled and certainly have a reasonable expectation of privacy with respect to the diary that you keep and the papers that you have there and the communications that you engage in inside the privacy of your home. But heretofore, you never were immune from a government search of your residence. You were never immune from a wiretap on your phone or a microphone in your residence, so long as the government followed the law and adhered to the Constitution. And so the question now is, we're talking about a world in which you or a threat actor would be immune from collection by the government. And the question that we're asking is that the world that you want, that you, the American people, want? But we're telling you, we're not trying to dictate solutions, but we're telling you this is a problem. You have to understand we're experiencing a problem, and you've entrusted us with certain authorities and responsibilities to protect the country, and there's a problem here.
If you go back and listen to a radio interview a television interview that President Obama had about a month ago talking about encryption, he made an extremely important point. He said, I think we have to have the discussion now about what happens the first time something happens where we captured the conversation and we couldn't understand it because it was encrypted. Now, each of us who listens to that conversation listens to the nuance of tone of voice and the gesture and so on. I, sitting on one side of the encryption debate, certainly heard one thing that I suspect my colleagues from the government heard something else. I think the president is absolutely right. That's the discussion we have to have. I haven't heard in the last 15 years very much discussion from the government about resilience. I think that has to do with the fractured Congress we have and the fact that anytime someone says, look, there'll be an attack and we can't prevent all attacks, and they're lone wolves, and there's nothing we can do. And we have to think about what the balances are, understanding that. Until we discuss that publicly and admit that publicly, we hear extremes discussed instead, and that doesn't do any good for anybody, and it doesn't do any good for security either.
So I just wanted to throw in 2 points sort of in response to what Jim was saying. And, and this goes back to my point about classification and secret law. Apparently, the government thought it was following the law. The government but it was following a law that the rest of us did not actually know about, right? In the 215 program, the way that the term relevance and the way that entire provision was interpreted for call detail records did, in fact, authorize bulk, mass, suspicionless call detail records. And there really were, even among the fairly paranoid, I think, a bit of surprise that this was actually blessed by the FISA court as opposed to an extrajudicially authorized program, a pure presidential sort of program. So, I mean, I think that I don't take too much comfort from the idea that they are following laws that we don't actually know the meaning of or don't know the concrete context in which they're being applied. I think that is that's just not a high enough standard that we should be maintaining in this area. The second point again goes to is a corollary on that, which is the bulkness of acquisition versus the minimization approach. I mean, there is a lot of, everyone loves minimization because minimization allows you to take in as much as you want as long as you take care of it later. But again, that's not how I think the Fourth Amendment was ever intended to be read. And I think that it's also, extremely problematic from a policy perspective, which is why any interpretation of these kinds of authorities in a bulk manner is highly significant. And yet, every indication we have is that for years, either legal opinions that are apparently precedent within the executive branch or judicial opinions have been allowing bulk collection on theories that once exposed seem at least questionable and definitely very, very much debatable. And we haven't had that debate, and we wouldn't be having that debate if not for these leaks.
More questions over here.
I don't mean this to be flippant, but the term wartime was raised. And that's a banner that's raised for special needs. Procedures have to be done under that. We've not had a declaration since the Second World War. So I'm wondering what the legal framework is for that. And more broadly, as applies to communications and technologies, we have several agreements that are being negotiated, a trans-Pacific, a transatlantic, an information one. They're not treaties. So they get away outside the Constitution with the requirement for ratification. So I'm wondering, what is this atmosphere that we're doing this under legally?
So I'm not sure about the last part of your comment, but with respect to the first part, Congress authorized the use of military force after 9/11, and all three branches of government, the judiciary, the executive, and Congress agree that we are at war. I'm no, international legal scholar, but my understanding is that, you're not going to have another declaration of war post-UN Charter. So what you're going to have are authorizations for the use of military force. That's war. That's what Congress authorized. That's what I was referring to.
He wanted to know how it relates to surveillance. How does
the point is that the surveillance activities were directed at obtaining the communications and information pertaining to the enemy against whom we were at war. That's the point I was simply trying to make.
But it's just a broadening of a foreign intelligence collection for enemies of the United States or agents of foreign powers. I mean, it's just, right?
Well, I'm trying to focus on the 215 program is what I'm trying to direct my comments
Got it.
at,
Okay.
which seems to be the subtext of what we're talking about here in some of these comments.
Right. Over here. Wait for the microphone.
One point, when you collect the data, the responsibility to protect the data, if you collect large data models, the standards that you have, I don't know anything about this, but if you have keys that open models and stuff, and obviously you have standards and responsibilities to protect that data where you capture individual data in the process of ordinary business. We're talking about security and data, and there's one element that we didn't talk about, which is maybe for somewhere else, but the point that we collect individual economic data in the Department of Treasury for personally identifiable economic indicators of an individual, so like your social and going around, and then the health indicator, all of those things have been parts of major breaches, and I think that's part of security too that we didn't touch upon, is that those are two significant identifiers that are very much at risk, and that should be, I know you've got that somewhere, but I think that's a risk too, is when you have big data models with that in there, that you've got individual data that can be hacked where you are, and the protection of that's also important too, and I'm a little bit off track, but I wanted that with you.
Obviously, maintaining the security of whatever data we obtain pursuant to any investigative authority is hugely important to us. We're very worried, as everybody else is, about malicious cyber actors as well as the insider threat. So we try to do everything we can, and we have an obligation to make sure that the data that we collect under any authority is secure. That's absolutely true.
Any other questions? Over here. The microphone's next to you.
Thank you. I just wanted to ask the panel to address this issue we've been dancing around, which is the Fourth Amendment interpretation, which is really the question of rebalancing the implicit contract between the governed and the government, given that two sort of fundamental Cold War assumptions, I think, are out the window, and we haven't actually acknowledged it yet. And the first of which is that prevention is possible. So we have been this quixotic mission that's been given back to the intelligence community, who tries to do its best to say that we won't have another 9/11. It's an unreasonable assumption, and I think Susan addressed that in part. So what do you do if that's not an assumption? The second, which is that collection is expensive, and this is something that we heard I think at length from Ben. But collection's not expensive, and this is the question that I think is foundational then about what are the limits or the work factor that's involved for government to surveil its citizens. But fundamentally what we're talking about is what is the reasonable limit in which a group or a small group of individuals or a particular individual ought to be able to have a disproportionate effect on others, and where in the world, what level of work is required before that reaches sort of a level of criticality that we ought to be able to surveil them. I don't think we've had a values-based discussion about that.
So I'm not going to answer that because it's not a question for me, but before anybody else on the panel answers it, I was going to do this at the end, but it's the appropriate time now. Jim and I disagree on many, many things, but one of the things I've been doing over the last few days has been reading the released OIG report on the NSA collection. And Jim was a man in an extremely hard spot and argued very hard for a much broader read into the program, where we might have ended up in a very different situation. And I just wanted to thank him publicly for that. Now I'll let him answer whatever questions he has to or not answer. But as much as I disagree with him, I'm incredibly impressed. He said to me, well, that's why I got the gray hair. And I said, I'm surprised you have any hair left at all. So thank you for everything you've done.
Thank you. Now it's very hard to respond to your question. These are exactly the kind of things we worry about. And, as I think the FBI director has said, you should be skeptical of your government. You should worry about it. And I can't remember, was it Thomas Jefferson who said, vigilance is pain, Thomas Paine?
Anyway,
the price of liberty is eternal vigilance, right? And so we are going to constantly go through these kinds of debates as technology evolves, and as our conceptions of privacy evolve and the government's capabilities, whether it's cheap or expensive to conduct surveillance, I don't know, it feels pretty costly on my end. It's a lot of work that goes into it, a lot of effort, and keeping up with the volume and the velocity of change is really quite challenging. But I mean, that's why we're here. You know, that's why Kiran and I came here, to have these conversations, to listen to everybody. You know, it is a dialogue that we want to have. You know, should we have had more before? Probably, right? I agree. But as I say, you know, especially in the environment after 9/11, it's tough to talk about this stuff in a way that was not going to give some benefit to the people that we were trying to surveil. And it was just, it's hard, and we struggle with that, and we probably should have done a better job of it.
So, the Supreme Court actually has started to grapple with this question, although probably not in the way that you framed the question. But, you know, in the Jones case in 2012 about GPS tracking, you know, this may turn out to be the sort of most important Fourth Amendment case in 50 years. The government's position was, how could you conceivably have a reasonable expectation of privacy in where you drive your car in public? It has a logic to it. This was an accused drug dealer who was driving around. And how could he say that during the 28 days in which the government had a device under his car without a warrant, that he had a reasonable expectation of privacy in that? And, you know, Justice Alito, writing for 5 justices, says that technology has changed the equation. That surely you know that when you drive from your house to the grocery store, someone could be following you. But you don't reasonably think, you know, that your government is collecting and aggregating that information over a period of time, like a month, which could reveal, you know, every intimate detail of your life, who your friends are, where you worship, what you drink, who you're sleeping with. And so this is a way in which surveillance becoming cheaper, the government not having to make those targeting decisions, actually resulted in a somewhat surprising advance in Fourth Amendment jurisprudence, and one that the government surely did not expect when it went into that case. You know, we've seen another unanimous Supreme Court decision on digital privacy a few years later, involving whether the government can search a cell phone incident to an arrest. And, you know, again, you sort of got this digital is different analysis from the Chief Justice, who said, you know, just the sheer amount of information that can be stored on this device makes it unlike the other things that law enforcement would find in your pocket, and requires us to think differently about the Fourth Amendment. So I do think that that certainly in the law enforcement context, if not yet in the national security context, this conversation is well underway in the courts.
We are out of time. But I just want to say a few things. All of you have been really wonderfully generous and kind of good to one another, which is good to know. And I in particular want to thank Jim for coming down and having this conversation with everybody. And please come back. Thank you for joining us.
Thank you.
Yep. Thank you. No, thank you.